All right. Good morning, everyone, and good afternoon for those of you who it's the afternoon. We're really excited to be hosting this panel this morning, panel discussion on regulatory compliance challenges. I know a lot of companies have a lot of regulatory compliance challenges, and we thought it would be great to bring in two leading experts in some of the most regulated industries, one of the most regulated industries in the world, oil and gas pipelines. So we're really thrilled to have so many attendees from so many different locations and different companies. As I already mentioned, you can put into the chat your background, your level, your different interests in regulatory compliance, and any questions you might have. Without further ado, I want to introduce our speakers. We have two leading experts on regulatory compliance, as I mentioned. So I'll kick it off. We have Kate Page and Jessica Tran. So Kate Page has held a number of senior positions at TransCanada in the last 10 years, and Kate is now leading the legal registry team at the company. Her team supports ensuring compliance for the Canadian and Mexican operations of TransCanada. Kate began her career as an economist, developing carbon trading regulations, and then worked for several power corporations, originating and trading carbon credits throughout North America. She's also won a series of consecutive leadership awards for leading TransCanada's involvement in investing-led reporting on carbon disclosure. So we're very honored and thrilled to have Kate Page here to discuss some of the work she's done at TransCanada. And Jessica Tran. Jessica Tran is a regulatory advisor at Trans Mountain Corporation, which operates Canada's only pipeline system transporting crude oil and refined products to the west coast of Canada and the US. They deliver over 300,000 barrels of crude oil and refined products each day through 1,274 kilometers of pipeline in Alberta, British Columbia, and Washington State. Jessica began her career practicing corporate and intellectual property law at a small law firm. And after a few years, she moved to Deloitte, where she was part of contract risk compliance and focused on third-party risk, looking at process and technology solutions, performing inspections on third-party business partners on clients' behalf, and assessing third-party compliance with contractual terms and conditions. At Trans Mountain Corporation, Jessica is the lead for the design and execution of the company's legal registry and legal requirement monitoring process, which includes establishing a management of change process for these legal requirements. Jessica works with different programs to ensure compliance with applicable legal requirements, including legislation, industry codes, industry standards and codes, as well as regulator orders and certificates. Jessica is also responsible for monitoring applicable legal requirements in Canada and the US. Jessica holds a Juris Doctor with a focus on intellectual property law from Thompson Jefferson School of Law in San Diego, California. So both amazing backgrounds, tons of experience. I think a lot of scar tissue from trying to respect regulatory requirements. So I think it's gonna be a fantastic talk. And we're going to be recording this talk. We're going to be sharing it with the attendees, so you'll all receive a copy afterwards. If you have questions, put them into the chat window, and we're going to have a good amount of time at the end for Q&A to really dive into this. So this is the second session of the day for the Mnemonic EHSQ Online EHS and Quality Compliance conference. We did one this morning on ISO 14001. This one right now on regulatory compliance, and there's one this afternoon on quality management system compliance. So we're really thrilled to have you and honored to have everybody on the call today. So let's get into the panel with Kate and Jessica. Kate and Jessica, if you want to add to the bios that I just read, feel free to. And then we can kick it off with discussing the NEB onshore pipeline regulations.
Okay. Yeah, I don't have anything to add to the bio myself, so I'm
all
good.
right. Okay, great. So, I guess I should introduce myself very briefly. My name is Jonathan. I'm the CEO and founder of Mnemonic, and I've worked closely with Kate and with Jessica on their respective projects. So I'm really thrilled to see them and thrilled to have them on this panel. So let's kick it off. So Kate and Jessica, what is the National Energy Board's onshore pipeline regulation? I mean, there's some people on the call that are from the industry, but there's a lot of people who are not. So let's try and give them a bit of an overview of what the regulators did to the pipeline companies.
Sure. So I can start it off and then pass it over to Jessica, who will provide a little more legalese to it. So the National Energy Board regulates our federally regulated pipeline assets in Canada, and the onshore pipeline regulations are the regulations that outline our requirement for our legal registry and how we monitor legal requirements and maintain compliance to them for our respective organizations. Now let Jessica provide more information.
So since the focus is on legal requirements, obviously there are select sections within the OPR that focus specifically on the requirements of legal requirements. Specifically, for everyone's knowledge, 6.51 focuses on the management system and basically says that a company shall, as part of its management system and the programs referred to in Section 55, establish and implement a process for identifying and monitoring compliance with all legal requirements that are applicable to the company in matters of safety, security, and protection of the environment. H says establish and maintain a list of those legal requirements, and I, we are required to establish and implement a process for identifying and managing any change that could affect safety, security, or the protection of the environment, including any change in the legal requirements applicable to the company.
Yeah, so the OPRs, as we call them for the acronym relating to the regulation, changed in 2013 and added new management system requirements, which Jessica just provided more information on. And that really outlined, as she provided the details of, we have to have a list of all of our legal requirements. We have to have a way to maintain that list, and then also have a way that we evidence our compliance as an organization to that list.
And was this, when this came out in 2013, was it a surprise, or was it something that had been discussed both with industry and within the regulator for a while? Or was this something that you saw coming, is basically the question?
I think we saw it coming. I mean, in previous audits before 2013, they were already looking at legal requirements at the program level. So I don't think it was anything too surprising. I think they wanted to get something more actually in the regulations around legal requirements, which is why it came about. But they were already auditing on it previously.
Okay.
Yeah, and it is in broad goal-oriented description of what they want to achieve, and they had provided a bit of direction. As any change in regulation, there was an opportunity to be aware of it prior to it coming into law. So it wasn't so much a surprise of waking up one day and it's immediately law. There was those regular stage gates.
And when it came out, did the government provide a good amount of context to help you understand how to interpret this this specific section of the regulation, or was it more, here's the regulation, you know, deal with it? What level of support, let's say, did the government provide your industry with here?
So TransCanada was the first organization that was audited against these new OPRs for our management system. We had about half of our management system programs were part of a broad, comprehensive audit that they conducted. And it was really through that audit and our corrective action to that audit that we have received over the last 3 years additional direction from the National Energy Board as they have evolved and we have evolved on understanding what this goal that they have of having a list, managing compliance to that list, and then maintaining it really means in practice, and also for their auditing purposes, the level of detail that they want to see and understand.
Yeah, at Trans Mountain, we got audited, I think, shortly after TransCanada, and it was a focused audit on one program as well as the management system piece. So it was, yeah, they looked a little bit more in detail at legal requirements at that point, recognizing that they were looking at one specific program as well as generally. So the one specific program had sort of a finding for them as well as the general management system piece. And then we've been audited a couple other times since then.
Yeah.
Again, same thing, looking at legal requirements. And yeah, we kind of learned from the audit what kind of detail they were looking for, what the expectation was, what their definition of a legal requirement was. So I think there wasn't so much detailed information provided at the beginning, at the front end, but it was provided through the audits as the auditors got more involved and in the audit reports.
Yeah.
Right. And so what are the, I will get on to the next question, talking a little bit about the programs that are included in this, but just before we get there, what are the consequences of the audits? Like if you have there's audit findings, I mean, I guess the question is, how seriously is the regulator applying this regulation, and what are the potential consequences for non-compliance? And maybe if you can discuss a little bit how that has driven the initiative within the companies that you work at in terms of the level of resources and allocation of team and people to make sure you're in compliance. So how seriously or what are the consequences of non-compliance for your organizations?
For TransCanada, they're very serious. We have heavily invested in ensuring. So initially, from our audit, the way TransCanada organized their legal requirements and their what we call now a legal registry was decentralized. So it lived within each different department and group. They managed it. And as part of the audit, we were found that the inconsistencies or just differences that were done group by group didn't meet the expectation of the NEB, the National Energy Board. So as part of our corrective action plan from that audit, we developed a centralized management of change process, which is now our corporate management of change process relating to legal requirements, where my team identifies, with the support of the subject matter experts, legal requirements, so that's regulations, standards, codes, permits, orders and certificates that have enduring conditions to them. So that's the post 30-day construction period is our general definition that we follow. And through that process, we have a central system that everyone in the organization has access to. And then those subject matter experts work and identify what is applicable within a regulation down to the provision level. So the clause level in Canada is how things are managed as the direction of the National Energy Board. They have deemed that we need to manage our compliance to the lowest applicable level is the written direction that we have received from them. And in our central system, we have that regulation, the identified applicable requirements, and then we have mapped out on a provisional basis those compliance documents that are used every day throughout the organization, which really evidence our compliance to those requirements. So it's a broad mapping exercise. It's now centralized, but we work and the ownership of the accuracy and accountability of it being complete does still lie within the business. So it's a broad governance program that we now execute at TransCanada versus that decentralized approach. So it was one key learning that we had and just kind of reinforced how important it was for the organization to meet those responsibilities that the National Energy Board has outlined for us.
Mm-hmm.
Yeah, I think it was similar at Trans Mountain as well. I think the consequence of the audits was the finding that essentially our legal requirements was insufficient or were insufficient. So it was a matter of finding out, we didn't really have one overarching process that went across the board to all programs. So we had to then develop a process, a procedure, one cohesive list of legal requirements, which our list is similar to TransCanada, as you know. It has legislation, regulations, standards, codes. We have permits, we have orders and certificates, we have safety advisories on ours, board safety advisories. So it's one cohesive list that we are required to maintain. But we found through an audit after our first audit that legal list is not what you would necessarily perceive a list to be, a title list. It has to be down to the lowest level, as Kate said. So it has to be down to the provision or the clause level or subclause level. So the lowest possible detail.
Mm-hmm.
So at that point, we realized where our deficiencies were. And I don't think it's still so much the consequences. It has benefited the company in being able to pull together one process for legal requirements, monitoring, ensuring that it flows across all the programs. I think that's kind of how it came to being in ours. So it wasn't so much a consequence. I think a consequence in the sense that we had findings as a result of the audit that our legal requirements were insufficient, but beneficial in that it helped us correct those errors and make it more centralized.
Yeah. And we'll get a little bit to what exactly is a legal requirement within the within this context. But what are some of the programs that are included in the management system based on this regulation? So kind of what's the scope of the management system that they're trying to get companies that are subject to the regulation to implement?
Well, that includes programs like integrity management, safety, security, emergency management, damage prevention, environment. We include engineering or capital projects. Kate and I were talking, we both include control centers, SCADA for us. Public awareness is another one of our programs. So I think it depends on the company as well, but generally it's any program that can have effect on safety, security, and protection of the environment and people. Yeah.
And how much of this was new to your organizations, that in the sense that you didn't necessarily have this in place when the regulation came out and you had to put it in place, and how much of it was managed systems that you maybe already had, maybe it was decentralized, but you were able to pull them together to ensure that you were meeting the expectations of the regulation?
I think for Trans Mountain, it was fairly good at the program level. It was just a matter of making it more central and recognizing that we had a deficiency and that we didn't have one process and everyone was consistent across the board. So at least that's what our findings were. So.
Yeah, ours was more of a large change management exercise of taking existing work that was already being done and centralizing it, and then also helping the subject matter experts transition how they do their work on a daily basis to our new governance program, where we have centralized monitoring of legal requirements. So there's no more duplication, as an example, of having multiple services monitor legal requirements. And we've also centralized our analysis relating to changes in regulation, standards, codes, so that there's more of a broad central view over the whole regulation, and then subject matter experts provide more of that technical review and analysis that's particular to their team that they used to always do. But now we ensure there's also an overarching.
Mm-hmm. Okay. And so when it comes to the term legal requirement, at Mnemonic, we've seen different interpretations of what is a legal requirement. You mentioned earlier, Kate and Jessica as well, that the regulators have asked you to go down to the lowest level within a regulation. We've seen companies that say, I've identified the regulations. I think I'm compliant to these regulations. And for them, that's, the regulation is the legal requirement, versus maybe the other extreme is what this regulator has asked for is to go all the way down to the clause level. And maybe you can walk some of the attendees through what that really means, because I think what is your definition of legal requirement under this regulation, and what have been some of the challenges of getting down to that lowest level and of assessing your compliance?
Do you want to? Happy to go. Sure. So for us, we used to manage and at least map our compliance out to initially to the National Energy Board. We had submitted a registry that mapped our compliance to the section or subsection level. And then based on additional direction we've received from the National Energy Board, they wanted us to take that same type of mapping exercise and go further lower. So if there's a paragraph or a subparagraph or a clause, then provide that mapping to that lower level versus rolling it up. They feel that there's additional value in them seeing what is specifically applicable to an organization versus more the overarching. So for us, we managed it previously at a bit higher level, and now it's been a larger exercise to not only assign but also manage that information to that lower level. And that's where you really need a strong system to be able to manage and house that type of quantity of data, but also ensure that your subject matter experts have the time to be able to identify and complete that work, because there is quite a difference in the number of hours that, say, at a higher level of identifying a regulation, even just reading it, but then to go through and say, oh, the following 30 clauses are applicable to me versus the 1,200 that are in the regulation.
Mm-hmm.
Okay, my computer froze. I'm just gonna.
And did Jessica's computer freeze? Oh, okay.
Sorry.
She's so still. She has such good, good posture.
All of the faces on my screen are frozen, and I can't click anything. Anyway, okay, answer the question. So legal requirement for us, so we initially had the title list, and before we made one centralized system, the programs typically went a little bit lower. They kind of use their gauge on that one, but they typically went a little bit lower. And so what happened was, once we made the centralized list, we got audited on that. We knew we had to go to the lowest level, not only for pulling out each, subsection. So if it's, 6.51, you need a separate line item for A, B, C, D, E, all the way through, so that each line item has a compliance assessment to it from the applicable group. So it took some going on that, but that's our understanding of what a legal requirement is. That's the expectation of the board through the audits we have had conducted. And I think it's also the same thing with our orders and certificates. It's any applicable or any condition where there's a requirement as a result, you need to have a compliance assessment for that as well. So a compliance assessment for us is, where in our document does it exist, what document, and then a brief statement about how we illustrate compliance. So we've done that, or we're in the process of doing that for our legislation as well as our standards and codes and our orders and certificates as they're coming in. So, yeah.
And so getting down to that lowest level, it seems like a really big challenge, because in regulation, sometimes you'll even have multiple requirements within, say, the same sentence. There's no actual differentiation between an A and a B or an I and a double I. Do you feel like the goal of the regulator is that they want to have you really say, this specific requirement, this is how we're complying, and not say, if you have an oil tank, you need to do A, B, C, and D, but they want to say, okay, if you have an oil tank, are you doing A, B, C, and D, and then demonstrate each individual one? And have there been situations where you just haven't been able to necessarily break up, like say that, one sentence with two requirements? Have there been situations where you've struggled to break up the requirements, either because they're very interlinked or because just the format? Have you struggled with that at all? And has the regulator given any input on that?
For us, we have it managed individually by group and then consolidated within SAP, a large custom-built application, so that it is actually individualized per team and then rolled up centrally for the organization. So there isn't that difficult element of assigning one group per provision.
Okay.
As an example, the onshore pipeline regulation, we have approximately 50 teams on it, and, hundreds of individuals. And in some cases, we have over 100 different compliance documents evidencing how we're meeting that. And so for the regulator, they wanted to be able to see distinctively, if I'm auditing environment, then which are applicable just for environment, what are those individualized compliance documents, and then how are they meeting that? So for them, it ensures that it's very clear, distinctive for them, so there's no second guessing.
Yeah, for us it was, we haven't really had an issue breaking it down to the lowest level and assigning it, because I find something that low, it's rare that it would never not happen, but it's rare that it would apply to multiple groups because it's so specific. So we're able to assign the lowest level to a team integrity, for example, and they would have to provide an assessment on that. And it's never been an issue. And then, yeah, the auditor wants to kind of see if they're looking for things that apply to a specific group. They want to see the requirements that apply to that group only. So we're able to pull those out for them and say, here are the ones applicable to integrity or environment or whatever. And we've sort of created teams as well for things like our management system. So it's something our management system covers. Then we give it to our compliance or management system team, and they would provide an assessment for the management system piece, as opposed to having every group provide an assessment saying, well, we kind of address it in our management system document, but really it's covered up above in our overarching management system piece. So that's kind of how we've broken that one up, so we don't have multiple groups essentially giving the same assessment, but in their documents, because really if there's an overarching process, that one's the one that is being referenced in that case.
So do you feel that, yep, sorry, go ahead, Kate.
Oh, I was going to say my colleague, Christine Nichols, who is our lead on environment, provided actually a comment in the chat box if anyone wants to read it. She's just talking specifically about the work she does and how she relies on when there's a change, as an example. We have a general analysis that we send out to our subject matter experts analyzing that change, and then she and her team provide technical analysis for environment. But then if they share that regulation with other teams, she's able to see the other technical analysis to ensure that it is covered off within the organization. And also for her analysis, Christine, if this is appropriate, is considered. So she has also many times identified that this change isn't applicable to my team, but please ensure that you follow up with the following additional groups.
Yeah, that's the same case with us. If we've assigned it to a group, or a group's been assigned to a particular provision, and they go, well, it's not really ours, it's someone else, we're able to work with that as well. So especially in the beginning phases, you're trying to establish that baseline for assessment. So, you assign it to a group that you think is the one that would cover this area, but in some cases it's unique. Certain groups say some companies cover it, but we don't. So then you have to give it to the correct group in that case. So it's a little bit of that as well. But I think to Kate's point as well, you do get that notification at that very low level for the applicable group, that then they can go and review, see what the change is. If it affects their program, then they go and, speak to whomever in their program that needs to make that change in their documentation, whatever. And then, the compliance assessment gets updated accordingly as well. So if now there's a gap, whereas there wasn't one before, you need to address that.
Yes.
Right. Yeah. And that is at that very low level. In the case, there are some cases where, for example, we don't do sour service, right? So in cases like that, we have our subject matter experts. We still sign it some. They have to say it doesn't apply, and just a brief statement why it doesn't apply. So if it doesn't apply because we don't do sour service, just say it doesn't apply because we don't do sour service. It's been a positive exercise for them to just kind of look at it and reassess and their program, their documentation, all that. I think it kind of helps them a lot. It's a lot of work, but it's been positive.
One of the great things that we have seen as a key benefit from all of this work is actual consistency throughout the organization on understanding regulations, understanding what is applicable to the regulation, but also analyzing that change. And so there's that centralized, consistent understanding, and also direction from our legal counsel in-house. My team is based in corporate compliance, but one of our key contributors is a core team of lawyers that support our subject matter experts and us on the analysis.
Yeah. I mean, it sounds like though this past maybe 5-6 years of trying to comply with this regulation has been challenging, the fact of going down to the lower level and getting all these parties involved and centralizing the information has provided both your organizations with a much more comprehensive and complete portrait of your regulatory requirements, as well as actually educate some of the different program managers and specialists in terms of what the regulatory requirements. How much, I guess one question for you is, through this process, how many new, like genuinely new requirements did you discover? Was there a lot of stuff like, wow, okay, we didn't even know we had to do this, but through this process, we now have a documented way of meeting these various requirements? And how much of it was you already knew you had these requirements, but they were really just managed in a decentralized way where different teams or different business units were kind of on their own?
I think for us, it wasn't so much, oh, I didn't know I had to do this. It was more because it requires so much detail and you having to look at your documentation and your program and see whether it exists. It was more, well, we're doing it maybe in the field, but it's not covered in our documents. Oh, we need to include that. So it was more of that realization than, oh, I didn't know we had to do that, because from our group anyway, it's been, they're comfortable with what they need to comply with generally. I mean, if something new comes up, they have to deal with it. But it's never been an issue of that. It's been more, it's not in our documents, but we're doing it in the field. So now we need to make sure our documents are compliant. So it's been a lot more of, I think, making sure that our documents are consistent with what the requirements are, and ensuring who the reader of that document is and that they're getting the right information based on what they need to understand and comply with, and doing that piece.
And so, I mean, if we just kind of summarize a little bit, at the end of the day, what's really required to make the NEB happier, to come into compliance with the onshore pipeline regulations? Maybe that's an open-ended question. You don't actually have the answer yet, or it's an evolving set of requirements. But at the end of the day, what, in your opinion, would satisfy or has satisfied the NEB with regards to this specific regulation?
Yeah, and based off of what we've provided, both of our companies, not to fully speak on behalf of Jessica, but both of our companies have received satisfactory statements from the National Energy Board on our current information that they have seen and shared. A registry, a legal list is never finished. It's never stagnated. I like to always refer to it like a great bottle of wine. Every day it changes and evolves, and maybe one day it'll be perfect. But a key element for us is all about continuous improvement and ensuring that, and it's a key element outlined in the onshore pipeline regulation for management systems, is a continuous improvement element. So for us, it's all about ensuring there's kind of changes, but then also following the expectations that we have received from the NEB relating to these requirements.
Yeah, and I think on that as well, it hasn't been a negative experience. I think working with the NEB to kind of understand what is required for compliance has been very positive.
Sure.
And having those discussions with like our lead auditors for our audits has been, you know, we're not trying to get perfection in what you're saying in your assessment, because it's really for internal purposes, right? I mean, Kate's team, her company is going to use their assessments to deem where they have gaps, where they have deficiencies, areas for improvement for them. It's not for the NEB to come and smack you on the wrist and say, well, bad for you, you have 10 gaps in this piece of legislation. And they've told us time and time again, it's more for internal purposes, for you guys to understand how your company is running, how, you know, where you have gaps, that you are compliant, give you peace of mind. So I don't think it's so much looking at it as we have to be compliant and it needs to be done a certain way and it has to appease the NEB. It's more, we recognize you need to have this done, but they're not literally going in there and looking at every assessment and saying, yeah, this looks good, oh, you need more information here, whatever. They just want to see that it's done and that you guys are recognizing those gaps and addressing them and have a process for that and a process for monitoring any new changes.
Yeah. At the end of the day, they've outlined their expectations that it's goal-oriented, and that's the OPR overall. And so they're not providing prescriptive elements to us. The way TransCanada manages it is slightly different than the way Trans Mountain does. And so, and that's the wonderful thing that we've really appreciated and support from the NEB is they set the general expectation, and then it's the responsibility of the business to choose and figure out what meets our needs best.
Yeah. And so do you feel that this process has taken both your organizations from a more potentially a more reactive sort of regulatory compliance culture within the organization to a more proactive one where you're proactively identifying new regulations, the requirements, and making sure they get out to the right groups and they get added to documentation? Has this regulation, the onshore pipeline regulations, has it helped move your organizations from a more reactive regulatory approach to a more proactive one? Or was that something that was already happening regardless, or maybe something else that I can't think of?
For TransCanada, I would say our subject matter experts are exceptional in being engaged and understanding the changes that are happening in all the different jurisdictions that we operate in. And so I wouldn't say it is providing additional identification of legal requirements that they weren't aware of. I would say it comes back to that centralized approach of ensuring that everyone is aware of all regulations that are changing and that we can have more of that broad corporate approach on analyzing, is everyone that this is applicable, engaged and involved, and ensuring that their, say, compliance documents are up to date with the most recent version. And by centralizing it and using, in our system, a workflow approach, it's exceptionally well documented so that when we are audited, either from the National Energy Board or doing a Tier 2 or Tier 3 audit, we're able to provide that evidence to our different auditors so that they can see very clearly without additional hand-holding or additional written descriptions about how things are managed. Everything's well documented and continuously executed.
Yeah, I'd say that's the same thing for Trans Mountain as well. It was never an issue of being reactive. All our programs were already ensuring compliance with the applicable regulation standards and codes that applied to them. It was just a matter of centralizing it and making sure that it was consistent across the board in how we were doing that. So some of the groups still maintain staff on the side as well for their own purposes, but it was a matter of centralizing it and making sure everyone was doing it the same way. That we had one way to report up to our president, CEO, the executive on progress as well. They have one place to go. It's not everywhere, and everyone's doing it differently. It was more that than it being reactive. I think they've always been proactive. They've always been, oh, this is new, we need to make sure we're complying. Are we currently complying? If not, what do we need to do to address that? It's never been reactive at Trans Mountain. It's always been proactive. Yeah.
So it sounds like some of the implementation benefits of this was really centralizing the information and having a process in place to make sure that it's documented, that all the analysis and the links to the various documentation are actually documented, and you can then easily pull that out in the form of reports and other evidence for auditors. It sounds like that was some of the real big benefits of implementing a more this more robust and centralized system. What were some of the implementation challenges? I mean, you both are working at very large organizations with lots of people and very complex, and obviously often regulatory compliance is viewed as a tax on business. It's viewed as something that has to be done if you want to operate, but companies will often try and allocate the minimum amount of resources to compliance. And what have been some of the challenges with implementation? Was it difficult to get the appropriate people at your organizations to allocate resources and to take this seriously? Was it something that every year the budget got bigger and bigger as they recognized the necessity of compliance? I'm sure there was other challenges too, like getting people to have enough time to assess their compliance to different subject matter experts and business groups. But yeah, maybe just walk the attendees a bit through some of the challenges, the hurdles, and how you overcame them inside your organizations by getting the right people involved.
Okay. I find generally it has been there haven't been huge challenges. I think one of the challenges wasn't so much getting people to do it, but realizing the hours that would have to go in, or time that would have to go into completing the assessments, because it is very detailed. You know, it's a matter of them having to put time into reading the requirements and then finding it in their documentation and seeing if it is actually meeting, and if not, where else is it covered. So I think it was more realizing that factor, and then having the groups allocate the time accordingly to that, not so much that they didn't want to do it. You know, as a Trans Mountain person, we've gotten a lot of positive feedback from the program saying, you know, this has been really beneficial. It's brought out those, you know, those realizations of where we maybe do have gaps. You know, maybe we aren't quite addressing this properly in our documentation. We need to tweak it slightly or something like that. But yeah, it's never been an issue of getting buy-in. I think initially it might have been with every company to get the buy-in was hard, because you're looking at it going, well, we already comply. Why do we need to do this? What does this bring to the company? What benefit does this bring outside of, you know, additional resources having to now use that time to do these assessments? So I think the initial buy-in might have been a little bit trickier, but once you get people going and recognizing the benefit of it, it's significantly easier, and it's just a matter of allocating that time to do it.
No, definitely. So for us, it stemmed out of a non-compliance finding, and so the corrective action plan, there were many different other initiatives happening at the same time. So getting the buy-in, and also the time really for the same individuals working on building the registry, which is the time-consuming element of a legal registry. It isn't so much maintaining it, it is building it. Although for us, about 1/3 of our registry changes every year. So there is still a lot of time to maintain it required. But for us, it was really that value proposition to the different teams that we were able to get a lot of the senior leaders to ensure that they had their key technical subject matter experts engaged for a month or two to do that additional build out that was required. So taking their existing work and then putting it into our registry and going to that lower level than what they've managed before. It was definitely a struggle with some teams, where other teams saw the value that it would give. As an example, many of our engineers in training now have the ability, for those teams at least that have them within them, to run reports when a new EIT joins the team, that then pulls off all of their standards and codes that they need to follow and be aware of, that structure their work on a daily basis beyond those engineering specifications or additional supporting compliance documents. So that has provided value, that those teams didn't have that instant report kind of clicking in the past. And that has helped at least get the buy-in and also the time resource required.
So, I mean, we keep coming back a bit to this centralization idea, the centralization of information, so you can have that quick click and print a report for your new hire, so that they know all their requirements. Did you have to make organizational changes at your organizations in terms of hiring new people or moving people into a new organizational structure as you centralize this data? Was that part of the process? Was it not just putting in place a system, training people, getting buy-in, but actually putting in place an organizational structure that was more centralized when it came to regulatory compliance?
Yeah, for us it was. It wasn't initially. My role didn't exist until I think 2016 was when I was hired. So I know it was being done previously, but the realization that, you know, they recognized they needed a full-time person to commit to this and get it going. So there was that. They definitely, they pulled in that, you know, additional resource. I get help as well. Someone that in our company that's been helping out a lot with the legal requirements as well. So she's kind of come over and doing a lot of that legwork as well with me. So there is that that understanding that it required full-time resourcing. Beyond that, I know the groups have had to commit a certain number of hours. So in some cases, they might say, okay, we're going to be able to allocate this one person or these people to, complete as many assessments as necessary for, I don't know, for example, CSA Z662. So we're going to commit these resources. They're going to go get it done, and that'll be that. So it's been somewhat a shuffling process within the groups. I can't speak to our departments specifically as to whether they've hired people because they realize they need this done. Yeah. But I know that they have had to allocate specific resourcing to get it done, just because it is a big time commitment.
Yeah. Yeah, for TransCanada, it was a net new team that initially started with just myself and now has grown. And so that was a requirement for us to have that centralized governance function. But for our subject matter experts and technical teams, we really built off of our existing compliance programs and our management system programs to utilize the key leads and subject matter experts who are already engaged as part of our management system relating to that. So that so much wasn't net new. It was just an additional new title or role that they had.
Okay. So before we kind of wrap up the implementation part of this discussion, do you have, and there's some questions that have been coming in over the chat. I definitely want to address those questions and leave time for that. But in terms of implementation, do you have any other comments related to the implementation of this program and of these requirements? We'll get to sort of general recommendations for other companies, but from an implementation point of view, any other thoughts or comments on challenges and benefits?
Roger? Okay. Benefits we've had internally at Trans Mountain has been, like I've already said, that realization that it's been beneficial for the individual programs to see where their gaps are. And again, it's not that they're not doing it in the field or whatever. It's just that their documents might not cover it, or it's not as clear, or their forms maybe need to be tweaked a little bit. It's the comments I get are it's time consuming, but it's been really beneficial. And then it gives them an opportunity to go and address those. And in some cases, I've been told by one group at least that it's, they had to pull back in some cases, I think a few years ago on some stuff because it was just hard to implement. And now they're saying, they were getting, having some issues, and now they go back and say, well, it's a requirement, so we have to do it, guys. So we just have to figure it out. If that means more resourcing or whatever, we got to get it done. And it's been sort of helpful for them as well to say we have something to kind of force it and say we need to get it done. Yeah. So I think that's been, I don't know that there have been any major challenges. I think a big positive has been the centralization and being able to have everyone sort of that's also helped, I guess, with everyone's morale too, because they have a lot to do, but it's across the board. So everyone's able to kind of lean on each other, ask questions if they have them, work together to kind of understand it, or, how are you doing this? How is this working for you? I've heard that they've been doing that as well, which has been good.
Yeah, we had, when we implemented it, our largest standard that kind of governs our work is CSA Z662, and that actually changed 2 weeks before we submitted our final report to the National Energy Board. So it was a great kind of trial by fire to launch the program at the exact same time as we change our largest standard as an organization. And so it was able to immediately highlight that centralized knowledge sharing. We actually held for the first time in our company's history a broad workshop where everyone within the company attended to share information. We have 5 individuals who are on different committees from that CSA Z662 standard, and so they were able to present and share what changed, why it changed, and then the subject matter experts were able to actually collaborate, knowing that through the information in the registry of who actually uses which section, how are they using it, what's their interpretation, and so that knowledge sharing and consistency on the analysis was invaluable. And then also another key benefit we've had is just that centralized information. Anyone in the company has access to our registry and are able to run a report to understand how is this regulation impacting us? How are we managing it? What are our control documents or compliance documents that meet that expectation? And then the last key benefit has been our cost savings. So by centralizing our monitoring services, we were able to reduce a fair amount of redundancies. They weren't huge costs for TransCanada, but being able to at least have that central budget that now manages all of our monitoring, and even having a central individual that other groups who aren't as directly involved can still get access to different monitoring information, where in the past, because it was department specific, it wasn't as accessible.
Yeah, I find that so an also benefit for us, because it's all centralized in one location. You know, our compliance group has gone in there to kind of take a peek at stuff. Our regulatory group has been able to use that in some cases for them as well, to kind of see if something is applicable in some cases, if there's been a change. So it's been beneficial across the board, just generally having it centralized in one place where everyone has access to it that might want access to it or need access to it, to just kind of take a look, you know. It's been good.
Yeah, and I mean, we've definitely heard from many companies that the ability to quickly pull up legal requirements, like so let's say you have a contractor coming on site saying, you know, I don't want to do this, right? You know, you ask them to do something, they don't want to do it. And, or even forget about contractors, just even internally, being able to pull up and say, look, you know, under this article and this regulation, we need to do it. And usually then they tend to do it. Nobody wants to at least publicly break the law. So I think having that easy access information centralized allows you to encourage your teams or encourage people to make decisions faster, rather than saying, oh, I have to go check, I got to go dig it up. And then, you know, 2 weeks later, you've actually forgotten to do it, for example. So in terms of interactions with the regulator, the National Energy Board, you mentioned a little bit earlier that it's, I think, been fairly cordial. They haven't been an aggressive regulator that are looking to put out fines or anything like that. So has the relationship, the interactions with the how would you describe that?
I was going to say fines are always an option, right? Like they have that as the last case scenario, which we always find is so otherwise it's been a really good relationship of a lot of learnings on our part and also theirs. Being the first company that they had audited for this new requirement, I would say we both had a lot of learnings from our perspective of what is the expectation, and also them learning about, okay, TransCanada is proposing to manage it in this way. Is this really meeting what our expectations are? And then we were able to have many conversations over about a year and a half to get that finalized. And then for us, understanding that that's the expectation and we need to meet that. And then for us internally, it's how do we meet that best for the organization and making those adjustments. So we've been really focused on that over the last three and a half years since the launch.
Yeah, for us, it's been a very positive relationship with the regulator as well. I mean, after, you know, our findings came as a result of our audits, it was a matter of working together and trying to understand what are they looking for. And they've been very open to having conversations to the extent that they can provide information as to, you know, what that might look like, what would be okay to do, so to speak. So it's never been anything where you give them a call and they say, no, we can't talk to you about this, sorry, figure it out. They've never been like that. They've always been very accommodating to the extent that they can be, obviously, as they are the regulator, in assisting where they can, providing answers to questions you have. And wanting to learn from the companies, what's working, what isn't working, what are the benefits, what have been some issues you faced in implementation and you know, getting this all done. So we've never really had any bad experiences with our regulator.
No, not at all. Yeah. And I know we're really looking forward to seeing some additional direction that they're, I think, anticipating to release in 2019 through their new audit protocols. So, which will be great.
Okay, good to hear. It sounds like all regulators should try and be like the NEB. So we'll have to send the video recording to other regulators. So well, kind of one last question, and then we'll turn to Q&A. There's been a bunch of questions that have come in the chat over the last hour. We definitely want to address them. But generally speaking, we've talked about how you've met this regulation, some of the challenges and the benefits involved. But more broadly speaking, what kind of recommendations would you have for companies who want to ensure regulatory compliance? They might not be subject to a regulation that's so clear or that's enforced like the OPR is, but for a company that has good intentions at heart and that wants to meet regulatory compliance, what kind of recommendations would you give another company potentially in a different industry?
Can we start? Okay.
Yeah, go ahead.
I think my recommendation would be, again, what's worked has been making it very central. And in some cases, companies may have this already, but for the companies that don't, making it very central, having a group that focuses on it, that brings in the subject matter experts to do what needs to get done, to provide that information, to kind of take some of that load off the programs and make it centralized so it is very consistent across the company. I think that would be one recommendation. I think to the extent that you can, develop a relationship with your regulator to get a better understanding if they are vague and what they're looking for, and if they're willing to have that communication with you, again, to the extent that they can provide information, do it. I find that there's been a lot of benefit out of that because they do see that you're trying and you do want to meet the compliance, meet the requirements. So they're willing to assist where they can. I think those would be probably my two big ones.
Yeah, I would say for us, we've had a lot of value. We have an enterprise system, SAP at TransCanada, and utilizing the interlinkages between our facilities and our legal registry and our incident system, and even just managing different types of potential non-compliances more cohesively, I would say that could be a lot of value and a way to look at the registry adding value so that if an incident happens, it can be linked back to, okay, what procedure wasn't followed? What legal requirement is that based on? Should there have been some maintenance activities? Having those connections can ensure there's a more fulsome picture for an organization to identify potential gaps or failings or successes. In the sense of, okay, there's a certain area or jurisdiction or region that is that has had, say, no incidences, and they've been able to manage their compliance documents in a successful way. That's a great way to highlight successes in an organization. So we've seen a lot of benefit with that connection. And so just taking the time, if you're not required by law, to implement it right away, to look more cohesively within your organization.
Yeah, I think that's been something that we've really sort of gone to or looked towards doing is getting that across the board. So hazards and risks, right? You want to make sure that your hazard list is tied into your legal register and your legal requirements, and your auditors are able to pull from that, and you have connection to your documents, right? Your control documents. So developing that, and I think. I'm not part of our compliance group, I'm part of our regulatory group, but there's been a fantastic relationship with our compliance group and the recognition that this is a big piece of it, right? It really speaks to the hazards and what those requirements are, and making sure that we're working together so that across the board, again, it's consistent and everyone recognizes the importance of the management system and this being a piece of it.
Yeah.
I mean, certainly, for better or for worse, a lot of regulations are developed out of accidents and problems that have happened in the past, different organizations, and so they're not usually coming out of Narnia. They usually it's because something bad happened somewhere, and then the government reacted and regulated. And it's from what you're saying, it sounds like one of the big benefits or one of the things you encourage other companies to do is to make sure that the legal registry is not a document sitting somewhere on a file server somewhere or in a binder, but it's really something, it's a living document that's changing and evolving as the regulations change, but also as your operations change, and that it's interlinked with your work procedures, with your training modules, with your documentation. And that's where you start to really see the value of it. And if it's just a list of regulations or a list of requirements, but it's not linked, it's really viewed as a cost. And
Yeah.
that hopefully I'm rephrasing what you're saying properly, but that's kind of what I'm hearing and what I think we've seen with other companies and other industries.
Yeah. So, I mean, if you look at the management system, everything that's come out of the management system is regulated, right? You're required to have a document control system. You're required to do audits every 3 years, and have, a hazard list. You're required to have inspection, measurement, and monitoring activities. All of that come as a result of the legal requirements in those regulations. So it's not so much that legal requirements are sort of a unique separate thing. I think it interlinks with everything within the organization, and getting that set up at the outset helps a lot along the way, because it really speaks to all those areas.
Yes. Yeah. When I first started and implemented our program, I actually did a comprehensive assessment of the management of our regulatory compliance throughout our organization, so all 3 jurisdictions. And I found by doing that, it identified really strong areas and seeing how they were managing it, and also areas that needed some additional support and direction. And by completing that and documenting it, it really showcased that the work that we were doing was needed corporately beyond just our NEB regulated assets. And so I would really encourage a company that isn't required by law to start with that, and then figure out what is needed for their organization prior to kind of going down the rabbit hole to the extent that at least Jessica and I have with the registry.
Yeah, because I mean, if you look, for example, emergency management, right? Yes. Your response to an emergency is dictated to you by regulations.
Yeah.
So your plans, your procedures, whatever, will speak to those. They'll address those issues. So already there is an interlinkage. The integrity program, I mean, you have CSA Z662, you have other pieces of standards and codes that pretty much dictate what your program is.
Yeah.
So people have to look at it that way and realize that it really is the backbone of a lot of what has resulted in the programs, right? And I mean, in our company, and I imagine for TransCanada as well, they recognize that. They already have it in their documentation. Legal requirements is a huge piece. So maintaining it that way is, making sure everything is intertwined, because it helps them as well, right? As opposed to seeing it as separate little things as part of the management system. It's one big cohesive thing that everyone feeds into. Legal requirements are really the backbone of everything that the companies do. They need to meet compliance.
Yeah, certainly. If you're not respecting the law, then all the other EHS challenges that hopefully organizations are addressing, the law should be the basis, and then you can build on top of that, of course, and go much further and try and reduce your risks and your environmental and health and safety issues. Okay, great. Well, I want to make sure we have time for questions. So let's switch to some of the questions that have come in over the last hour, and I think some recommendations and other ideas will come out of these questions. So if anybody on the call has questions, please just pop them into the chat, and I will read them off. We're just going to do this in the order that they came in, so no preferences. So I'll start off here. I think the first question is coming from Stephanie Chuchuk. I hope I pronounced your name correctly. And so she has 2 questions. So what system do you use to track your compliance obligations? And then do you track conditions that are not applicable to your organization? So those are her 2 questions.
Sure. So we at TransCanada have built a custom application in SAP, which is our enterprise management system, and it houses all of our legal requirements. It links up with our or electronic document management system, and then we work with Mnemonic to get the material that we actually input into the system and manage all of that in-house.
Yeah, and we use Mnemonic right now as our system for our legislation, regulation, standards, codes, and there's a separate area in Mnemonic where we've been tracking our orders and certificates and conditions out of that. And as to whether we address conditions that are non-compliant, for the base assessment for Trans Mountain, we decided just for that base piece, it is important to do it for everyone to just kind of get that out there and understand why things don't apply. We know that, but just to have it down, because you never know. Your business might change, and something
Right.
that was not applicable might become applicable, right? So we'd rather have those assessments in there and then just pull out, the applicable ones for the regulators, because that's all they, I assume, want to see, because that's what we've been told, and just give them those ones. But for that baseline, we figure there's no harm in putting in a quick assessment as to why something doesn't apply.
Yeah. And interestingly, I mean, for companies that we work with that are ISO 14001 certified and that build their legal registry because of ISO 14001, in Europe and Asia, and I don't know if this is anecdotal, I don't have any evidence, the auditors over there seem to be more interested in your determination of applicability, that you really need to prove that you went through a fairly wide section of the regulatory body, and you might have determined that 25 or 30% don't apply to you, but you've documented that, rather than coming to the auditor and saying, here are applicable requirements, but not having evidence of what did you assess for applicability. So that's just one finding that we've seen. So it's always healthy, I think, to make sure that you document the applicability determination process, and that you don't just end up with a document that only has the applicable stuff. So I think that's definitely super important whenever a company is developing their regulatory compliance.
Well, one other point on that too, Jonathan, is, for example, not all companies are in the business of always doing projects, right? Big construction projects. So you might have sections in, let's say, National Fire Code or NFPA 25 or CSA Z662, which apply in the event you are constructing, whereas they would not apply to operations. So having that assessment where it says, okay, well, it doesn't apply to operations, but would apply in the event we do a construction project, well, then okay, we have to now go back to those areas because they apply in construction but didn't apply in operations, and ensure that we're complying with those. Yeah.
Okay. Yep, for sure. Sorry, I'm just trying to pull up the next question here. So here's a question from Evan Baker. Are you expected to include all the lowest level details of standards, such as CSA and Z662, that are invoked by regulatory requirements in the legal list? So I guess, Evan, I think he's asking is, do you have to take all the standards and go to the lowest level as soon as they are mentioned in the regulations? We do have kind of two sets of standards often in general, is you have standards that are out there on their own and they're recommended either by industry bodies or just in general. And then you have standards that are actually referenced in law where it says, you need to respect this standard. And maybe talk a little bit about how do you determine which standards do you go to that lowest level of compliance assessment, and which standards that maybe you don't go to that lowest level or you don't assess at all?
Okay, so for us, what we do is the ones that actually apply to our company, we go to the lowest level. The ones that don't apply, we don't go to the lowest level. And it's just, again, because if it does apply, the regulator wants to see to the lowest level the breakout of that standard, that code, that piece of legislation, as well as then the compliance assessments to each of the requirements that do apply to you. So we would need to break that out. But for ones that don't apply, we don't obviously do that, and we don't include them in the legal register. For example, the OPR references some pieces of legislation that deal with, I forget what they deal with. Some of them deal with the processing plants. Well, we don't have processing plants. So when it says, you need to comply with this one, we just put a statement that we aren't in the business of, working in processing plants, so it doesn't apply. So therefore, we don't have to break that one down. So yeah, that's kind of the expectation is if it applies, they want to see it broken down to the lowest level and an assessment of compliance for each requirement to the lowest level.
Yeah, we've had issues with copyright issues with standards and codes, and so for our system, we have requested to each of those organizations exemptions, and have either received direction of support or being rejected, and based off that rejection, denial, then we enter the information that we are given the direction that we can. We still manage as an organization to the lowest level. There's no question of that. And we are fully aware of every provision within like CSA Z662. but within the actual legal registry, the CSA group has given us the direction that we are only allowed to enter the table of contents information into our registry, even though we own a large quantity of every individual that enters into the registry has access to an original copy of the CSA Z662. But even with that, we still haven't been able to get approval for that.
Yeah, and in that case, we've broken ours down to the lowest level, but it doesn't have any of the verbiage from the standard or code. So it's literally the number and then a blank line. So we've still done it to that extent because, our regulator wants the assessments to that level. But we aren't allowed to pull any of the verbiage in.
Yeah. I think we could do a whole webinar on copyright issues around standards. I've written a few articles. It drives me up the wall. I don't know if there's anybody from a standards body on the call today, but I mean, it just boggles my mind that the standards body should want you to comply to the standards. I mean, or else why write them? And then they put all these hurdles in front of you. And like you said, Kate, your organizations have already spent lots of money to buy the standards, but they don't want you to just change the format so that you can assure this compliance. It really, anyways, I'll stop there because.
And we contribute a great amount of time and money to the development of the standards also, which we absolutely support. There's no question on that. It's just more, I think the conversation needs to be had. And CSA has been working with the National Energy Board in providing free access to CSA Z662. They have limited it where you can't just get it off their website anymore. You have to sign into it. But still, that is a step in the right direction for at least everyone in the country to have access to it.
Yeah, it's and it's not restricted to the CSA. I don't want to pretend like we're just picking on them. This is a problem around the world, whether it's the American Petroleum Institute and their standards or other ones. It's a pretty common problem, unfortunately. I will highlight that China is releasing all standards for free now, which I think is a very good initiative because they say we want to move industry forward. We want industry to be respecting these various standards. So they have forced there was multiple standards bodies in China, like in most countries, and they've forced all the standards bodies over the next 5 years to release everything for free. So I think that's an example that hopefully will percolate to other places. All right,
hopefully someone can lobby Justin Trudeau.
I've tried. I've actually reached out to Navdeep Bains, who's the industry minister, but I guess I don't have enough pull. But I'll keep trying. So one question from Marcel Guevara: besides the legal registry, what level of detail on implementation and performance is the NEB looking for during an audit? Can you please expand? So I'm not sure, maybe Kate and Jessica, you'll be able to answer that question, but he's asking about the level of detail on implementation and performance. I don't know, Marcel, if you're still on the call here, but if you are, feel free to add to that question just to clarify a little bit.
I think for those ones, if I'm understanding correctly, when he's asking for legal requirements, level of implementation, well, the implementation would be in the documentation part of it, as well as the actual compliance assessment. So in our audits, we've been asked to provide our legal list. So of course we have to provide it broken down to the lowest level, and then we've provided those compliance assessments as well, just for reference. So we've provided those. They want to see those. They want to see that it's broken down to the lowest level. And again, the implementation is really in the documentation, in the field, what we're doing. So if we have compliance, because it's in our documentation, they see that implementation, and then they look further and say, okay, well, your documents say it now, are you doing it in the field? So they do go do a full audit to the extent that they, go to that lowest level in the field. Okay, you say, you need to maintain these records. You say you have that discussed in this document. This is your process. Now, show us those records. Show us this process you're actually doing. So they do go to that lowest level for implementation of legal requirements through their audits.
No, and we've experienced the exact same thing and follow the same requirements relating to Tier 2, 3, and obviously 4 with the National Energy Board.
Okay, great. Yeah, and Marcel just added here that you did address his question. So if you wanted to know if they were really looking at performance and not just, say, documentation.
They do look at performance.
Yeah, absolutely.
So Fred Gauthier is asking, cross-provincial pipelines are federally regulated. How do you deal with provincial and municipal regulations or bylaws? So, your pipelines cross provincial boundaries and into the U.S. What's your take on applicability of provincial and municipal regulations?
So generally speaking, yes, we are federally regulated. However, the federal government has generally deferred to the provinces for areas of environment. So you generally then end up going to environmental pieces, provincial environmental pieces of legislation as to how you need to comply. And there may be some health and safety and some other ones that are applicable, recognizing that you still have to meet all the federal requirements. But again, there isn't a federal water act. There are, provincial ones that you need to comply with, for example. So I think for us, we haven't gone to the municipal level. We've done provincial and federal to date, where it applies. And a lot of our provincially applicable ones are things like in BC, emergency management regulations apply, or the environmental pieces apply, or there might be some health and safety. So you just kind of need to see where you need to meet those requirements, because maybe at a federal level it doesn't really address it, and at the provincial level it addresses it a bit more. That's how we've done ours.
No, and we've done the exact same as Trans Mountain. I would also mention that for at least our registry, we need to ensure that anything that we put in it, we have a way to be able to monitor and maintain it. So even assets that aren't NEB regulated, that we're working with that business unit on building out their legal registry, we still have to ensure all of those legal requirements can be monitored and maintained. And so municipal bylaws would be a more difficult element to be able to have a centralized, at least, maintenance function and monitoring function versus, say, our community teams are very engaged with all municipalities that we operate in, and so they're exceptionally aware. And so the additional value that we've seen on entering that information into a registry versus them individually maintaining it isn't there. And so that is an example, at least as one group, that we have chosen to still keep that department decentralized management.
Yeah, municipal bylaws are we work a lot with municipal bylaws at Mnemonic, and the best case scenario is they're available online. The worst case scenario that we've actually seen and dealt with is where we have to do an access to information request to the municipality to get the bylaws, and they come in all sorts of different formats, and they're updated in completely different ways, and trying to standardize that data would be very, very challenging. It is very challenging. So at Mnemonic, we update municipal bylaws about every quarter, but we can't get down to that lowest level of detail, or at least not as easily.
Well, I think one comment to make too as well is, it may not be centralized for us, but I can speak, I'm 100% certain. Our companies, municipalities require you to get permits. Well, we ensure that we're compliant, so we go get those permits. So we do comply to the extent that we need to comply with, and those specific groups go out and get those permits, or they go and meet those requirements, but we just don't have it centralized right now in our legal list.
Yeah. Okay, I think I'm at the last question here. If I missed anybody's question, because there was a fair number of comments in the chat here, if I missed anybody's question, or if anybody has a question, please just pop it back into the chat. That way it goes to the top of the queue. But from Lane Tucker, he's asking, have you looked into RFID tags for asset tracking and construction management in real time, and tying the RFID tags to documents such as service manuals? So I guess RFID are those devices or tags that allow you to scan them and then pick up what the asset is. Have you done any work in terms of trying to link up the operations, walking up to a forklift or walking up to a specific pipeline and being able to pull up the right documentation? Or is that something that you've tried to do at your organizations?
Okay. So for our legal list, that is not connected with our asset management system.
Yeah.
So I can't speak to the work that they do and how they manage that.
Yeah, same thing with us right now. It's not currently linked.
Okay.
You do recognize typically where, if it's a health and safety issue, like you're going up to a piece of equipment, you need to know how to safely conduct your business around that piece of equipment. I mean, that's going to be in health and safety plans already. So in a sense, I guess it is kind of linked because those requirements would be in those manuals, those standards, those procedures.
Yes.
But we don't have a direct link that says this crane would have application with these pieces of legislation. We don't have that link, but you would have, it would be covered in some sense. It's just not that direct link where we have all of our, this facility addresses, these pieces right now. We don't have that per se.
Yeah, and we do, just for clarity's sake, we do have our assets mapped to every single piece of, actually every provision of every applicable legal requirement, but not the actual physical equipment.
Yeah.
Okay. But do you see that potentially as a kind of a future step, that eventually some sort of linkage between physical equipment and legal requirements might be beneficial, or is that just not on the horizon right now?
I would probably
feel free to defer if it's.
Yeah, I would have to defer that, and we would have to discuss that internally and kind of see what kind of feedback we get.
Yeah, our 2-year plan that we have for changes and advancements for the registry, that is not on our list right now.
Okay.
But I'm not saying it wouldn't be.
Yeah. All right, we got one more question came in from Stephanie Shuchuk. How do you manage documenting compliance evidence? Do you have tasks? Yeah.
So you mean like assigning it to people, and then I'm going to say if she means tasks, the way we do it is since we've assigned every sub-provision or every provision to a specific team or a specific group, yes, they have essentially a list of tasks where they need to go in and complete those. And now that's for the base assessment, mind you. They get notified in the event of a change, in which case that becomes a task that they need to address, and we have a certain period of time for which they need to go and address that. Any non-compliances, there's a certain period of time for which they need to take that away, figure out where those corrections need to be made and implement that. So in a sense, it is a task list. Yes, we do have tasks. I just don't know if it's necessarily the way that Stephanie's thinking of it. It is a task list for each individual group that needs to address items, but I guess it is maintained somewhat in a mnemonic, yes.
Yeah. For us, we have kind of 2 phases to our process. So during an initial build out or development of a legal requirement in our legal registry, we do have tasks or an identified gap, which becomes a task, which is tracked through workflow, and you do have a set period of time where you have to cover off and complete that work within. And then also when a legal requirement changes and there's actions, when there's a material impact to that change for the organization, there are tasks and there's evidence of what needs to be completed, what activities are impacted, what assets are impacted. There's risk analysis completed, and then they have a certain period of time where they have to complete those tasks and then close off and then update the registry.
Yeah, we have ours tracked in our workflow issue management system as well internally, so that we assign any gaps or any compliance assessments that need to be done to a specific individual or team. And then they need to address them within a certain period of time. And then, they need to have some sort of confirmation of completion. And in order to do that, they have to provide some sort of proof of completion. And typically right now, the way we do it at TransCanada is I close out all of the issues and actions that pertain to legal requirements, because I will have already gone through and reviewed the assessment, ensured that we've signed off on it, everything else. So I do that final close off and statement of, we've completed this, we've had sign off on this date, whatever. We don't have currently the subject matter experts doing that as it pertains to legal requirements, but they do need to provide that evidence to me. I review, we close it out in our issue management system, and it's tracked in there. And then in the event that, executives need to pull that, they can pull reports out of that as well for them to see.
Right. Okay. Well, I think that wraps up the questions. And if anybody has any last minute questions, feel free to pop them into the chat. Or if I missed one of your questions, I really apologize. Just so everybody knows, there's a survey when you leave or when we end the meeting. We really appreciate any feedback that anybody can leave about today's session. We're always trying to improve. So please complete that very quick survey at the end of this. So I think we're just going to wrap up. We got about 5 minutes left. Kate or Jessica, any kind of closing remarks on the challenges of regulatory compliance, lessons learned, things that you would have done differently or that you encourage other companies to do in a certain way? Anything at all, closing thoughts on some of these very big and evolving challenges?
I think hindsight is a beautiful thing. Yeah, I think the fact of would you do it differently, I think if you'd known back then, you would have started doing it the right way at the beginning.
Yeah.
So I don't think necessarily that I would do it differently per se from the beginning. It's been a roller coaster ride, trying to meet the deadlines as a result of the audits where we've had those findings. But I think it's been fantastic. The groups I've worked with internally have been fantastic. Working with even like Kate and some of our counterparts in the industry has been fantastic. The regulator, I think it's been great. I don't really have any downside to it. I mean, I suppose there's been a lot of hours going into it, but again, that's the nature of any business like this in any industry. And I don't have any comments on that. I think I already spoke to recommendations, just centralized for any company, and maybe your governing body doesn't require it, but it is a huge benefit to an organization to intertwine the legal requirements in a management system and throughout the company, and recognize that it really does basically run the business. All your legal requirements, you run the business based on these things. So I think it's a positive to implement it as earlier if you can.
Yeah.
Yeah, and from our perspective, we were focused on closing off a corrective action from a non-compliance finding. And so it's not that we didn't plan. I would say it's, in hindsight, it would be wonderful to be in a spot where you can take the time to identify what is your general scope, how do you want to apply this in your organization, what groups need to be involved, and follow true strong project management at least skills to implement that, because it can be exceptionally overwhelming to any group that's involved or to an organization. For us, our strongest implementation for different teams, as we've built it out across the organization, is exceptional change management integration from the very beginning to ensure that your stakeholders, your subject matter experts are aware of the changes, what is happening, and then also from a system perspective, making sure that you take the time to figure out, there's lots of things out there to figure out what does your organization need. Do you have something that already exists that you can build off of? Or is it better to have a web-based platform that anyone is able to access? So really taking the time to make sure your needs are identified and being met, and then engaging the right individuals at the right time.
And I think also it really has been a benefit, learning from Kate and some of the other counterparts in the industry, what they're doing, what their challenges have been, any recommendations they have. I would highly recommend that to other industry as well. To the extent you can, reach out to your counterparts, have those discussions, see what they're doing, what's working, what isn't working, benefits, pros, cons, what they've gotten from, your regulator, if they've had any communication with them, vice versa. I think as an industry, you want to be able to be strong and be able to say, we care, we want to do it right, help each other out. I think that would be another recommendation for sure.
Yeah, even just for your sanity.
Oh, yeah.
Because it is, at least for our industry, a newer requirement. And so being able to share learnings and experiences and also successes and failures is beneficial. So finding other at least companies or organizations or associations where you can kind of find counterparts has been exceptionally helpful.
Yeah.
Great. Well, I'm going to just kind of conclude and wrap up, and then we have sort of one question that I think we'll address, but maybe just after the conclusion because it's slightly off topic, but I want to address it just because someone asked. But I just want to thank everybody for joining today, and obviously especially thank Jessica and Kate for sharing their expertise, their knowledge. I think there was a lot of really fantastic lessons learned here that can be applied to any organization that wants to ensure regulatory compliance. If you have other questions, or if you'd like to see a little bit how the mnemonic system works with regards to updating regulatory information, feel free to come to our website, mnemonic.com, send us an email, give us a phone call. We're happy to show you what the system can do, and we're really grateful for the support of Trans Mountain and of TransCanada, and we're very honored to help them try and meet these onshore pipeline regulations over the next infinite amount of time, I presume. So thank you so much, Jessica, and thank you, Kate, and thank you to everybody who attended, and thank you for your questions and your attention. One last question here is a bit of a postscript. One fellow is asking about the assessment of carbon taxes and what your organization's positions are on assessing sort of the impact of carbon taxes or cap and trade on your organizations, and if you have an official position on that, and any thoughts you share on the carbon trading or the new federal regime on carbon taxes.
I'm going to have to defer that one. I can't speak on behalf of my company on that one. I'd have to say sorry. No comment.
Yeah, we definitely have teams that work on that, and we have many assets that are impacted as we operate in many jurisdictions that have carbon taxes and cap and trade regulations and other greenhouse gas regulations that impact our organization. Yeah. But that's another group. So yeah. Speak on behalf of.
I think the only thing we can say is, to the extent we need to comply, we absolutely do.
Right.
Yeah.
Make sure that we meet any requirements that are necessary. But as it pertains to any comments on views, we'll have to leave that to the groups that deal in those areas. Fair
enough. Well, thanks again for all of your thoughts, and all the feedback we're getting right now coming in is saying this was fantastic. A lot of people learned a lot of valuable information. So a big thank you, Kate. Thank you, Jessica. Have a great day. Have a great day to everybody who joined us, and thank you.
Thank you. Bye.
Bye.